Hello. Good morning from Diaspora. My name is Robert, and I am in Diaspora. And my channel here talks about the life and experience of Diaspora people with somebody in Diaspora. Diaspora means that this person has left a specific place and gone to another place, either looking for better pasture, either advancing his education. And that's not diaspora. There are many different diaspora lives we experience all over the globe. Some people who are in Europe, they will be called people of diaspora. People in the United States, and even other countries, even if they are not that advanced. People in Middle East, like Qatar, some in Dubai, some in many other places. So they are in diaspora. My channel now gives us a glimpse of our life in diaspora. In Diaspora Property, I discuss about how we, the people of diaspora, carry two lives on our hands. When you carry your home, you left a place. You came to another new world. You left uncertainty. The people back there, they believed in you. They had hope. They saw you have gone a better place. It's like you're going to prepare something better. You're going to change the lives of those people. So here in Diaspora Life, I discuss many things. I discuss like one of my books. One is Inside Kenyan Courtroom. What happens inside Kenyan courtroom? You are talking about litigation. You are a litigant, meaning that you are in diaspora, you are litigating things from outside the country. How do people think about you? How do courts adjourn cases? How cases are handled while you are in diaspora? That's your citizens, but as a diaspora person, sees once you put the airplane and go. No. So I go into depth discussing about the life and experience of diaspora life. So you can find these books at Amazon.com. But I'm not worried about the books. The theme here is about the life of a diaspora person. What really diaspora life is all about. Think about somebody you have come, you have walked, you have bigger dream, and you're carrying nothing than yourself. You have gone to a world. Uncertainty. Think of the United States. It's a system which is different. It's a fast moving pace. Things are so different. They're structured life systems. If it's you are late, if it's class, you have to be there. If you are late 5 minutes, they may cross the door. You may not enter to class, especially people who are dealing with nursing schools, even other classes, even a teacher. If he misses past 15 minutes, the student can walk out and move. That is the system. It's very structured, very ideal. What about the court system? The court system is also structured. If that talk of like immigration, if they give you 30 days to respond, you fail to respond, they can take you out. That is the legal system of the United States. Talk about Kenya. The difference between now people who live in Kenya, cases can go even 10 years without being educated. It's not that the people don't have facts or they don't have strong cases. It's because the system allows things to swell. Somebody misses court, a lawyer doesn't appear in court, your submissions have not been submitted in court. So that is the greatest problem we have in our system. All a case is filed, somebody says relying on a case, he never went to court, now you want to think that now he can change the facts. Somebody can file false documents and they will be dwelling within the court. That is what I discuss in my books. And we want to move from that system. We want to enlighten our people so that they are more informed about the system. They are more informed about what happens. Like my book, it talks about what's Article 40 of the Constitution of Kenya. What is Article 162? When was it established? What did it establish? What about the Act of 2011? What did it bring to Kenya? You think about those things. You talk about Article 50. Article 50 states about the fair hearing. So you have to be a very informed litigant in any court. It does not only apply for the people of diaspora, it applies to everybody. A lay person, a person can be in Kenya, and he has filed a case in court. And the lawyer tells him, "Oh, give me more money, give me this, give me transport." At the end, the litigant is frustrated because he thought he has won the case. Now, the surprising fact, the case, he didn't win. He has spent a lot of money. So we want to be very vigilant. We want to be very careful about what is really taking place. And we need to be informed. Once you are informed, if a case is filed in court, you want to make sure that there's submissions. If submissions, say a lawyer tells you, "I filed submission," or he tells the court tells him, "Go file a hard copy in court." You want to have verification. Verification means that you must have a certified copy so that the court cannot say later in another case and say, "Oh, this was not filed." So you have empirical evidence. When somebody tells you something and it was not done, it becomes surprising. Now there's conflict of interest. There is lack of trust. Now the communication barrier comes in because the person cannot explain what happens. So that is a very major problem. In my side, if there is a problem, there was something missing, you become realistic. If it's a lawyer, you tell the client, "Well, I didn't do this because I thought it would harm our case." Simple. You cross that. Once you cross that, then you develop a way. This is my strategy forward. This is what we need. This is how we are going to approach and win the case. So you become more informed. You parents, both the client and the lawyer, they are in one side. But when somebody goes silent, it doesn't help. So it is called maturity, emotional intelligence. So you grow to understand. You are informed litigant. So you know exactly what takes place. In court, things can happen. What matters in the ruling is what did the judge have at that time? Did he have the record of either your submission, your application, your evidence? Was it properly presented in court? So you think of such very important, very serious, very informative. So my prevalence, I dive into many things, not just a book like this one. It's written by Robert Mokua. That's me. I'm the author. And it talks about many things, good things, and you can critique what you think is right. It talks about the pages. If you look at the book, inside it has there has a hardcover. There's the author. There's an explanation of what he's talking about. This is the pie code for the book. And then we talk about other things. We talk about table of content. When you make a book, there are many things you think about. The manuscript is the book. There's table of content. There's the hardcover. And you think about the book was written out of necessity. You're talking about why the book was written. And then why the diaspora must understand the Kenyan court system. So you are in Qatar. You are sending money back home. You also want to understand the court system in Kenya, how lawyers behave, how the court works, what are your rights, your investment. You also understand many things to enable you to navigate while you are outside. You don't cease to be a citizen of that country unless you provoke and renounce your citizenship. But as far as you are a citizen of that country, you are protected by Article 40, which is protection of your rights to own property anywhere in Kenya. So you see that the promise of justice in Kenya. So you think about our justice system. We have laws. We have the constitution. We have articles that protect individual rights. And these are enshrined in the constitution. So they are there. The Kenyan court function, how does the court function in practice? So now this one, you look at what delays, omissions, lack of certain things that were not filed. So that is what you need to understand, the reality about the court. You may go there looking for a file and it disappears. What happened with the file? Did it have magic? Did it have wings to fly to go to heaven? It didn't. Somebody must have the file somewhere. So you start to understand how Kenyan legal system works. You may go to the police, they say, "Oh, our system is much different." We must understand. We must be informed. the power of procedure over truth. You think about that. The rate submissions. Sometimes in court, there may be rate submissions, and submissions are not made. A lawyer can come, he's hiding, he doesn't come, he doesn't appear in court, and the court makes that process as normal. It's normal to them. Eh? But you who is in diaspora, you are stressed, you may be so anxious, you are worried, what happened to my case? And then they may work their thing because they want to prolong. The more they prolong, the more financial strain it puts on you. They don't care about that. So you have to care about your rights as a litigant. Very, very basic and very important as a litigant. You understand, why did my submission miss in court? Why did the lawyer not come to court? Why did the judge adjourn the case to either 2 months instead of 2 weeks so that things can be fixed? So the judge may be trying, if the other party did not give the submission, it's giving them time, ample time to see what they do when one side is out. So assume one side submitted a submission, your submissions are not. That means one side's case was heard and your side was not. Legally, in Article 50, your case was prejudiced. It was not heard on merit. So you understand that basic law, the basic law that governs the court and yourself. Litigating from abroad. Litigation assumes presence. Court systems are designed around psychological availability of parties. The person, let's say you are litigating somebody in Kenya, and the person can access the court, he can move faster, can go visit his lawyer's office. You don't, because what you're relying is phone call. The people you are relying, you think you have given your trust to them. But now, because of what can happen, you need, if he told you that I submitted submission, you need a verification from the court, the portal, where like now the new system he filing, he need to give you a receipt. You keep on record. When submission, if he gives you he answers you, he says, I submitted submission on May 21st, 2025, and later, when the ruling comes, no submission. And the judge is questioning the case. They say, maybe he was certified. So judge is also pondering, trying to understand. He's also trying to inform when the ruling is out that the litigant who you understand that the judge is trying also to put this defense and say, no, maybe, so if the lawyer lied to you or told you otherwise, the lawyer is put naked before the law. He didn't do his job. That's what we call professional negligence. Professional negligence is the duty you hold to your client. That's called fiduciary relation between the client and the lawyer. So that is broken. Now you can either sue the lawyer and say, you didn't inform me, you didn't do this, I paid you, so you neglected my duty, you didn't protect me legally by law, and you didn't give me a specific explanation why this happened. So legally, you have those rights. But depending on why he did, maybe he was ashamed or he wanted to push the case in the right way, it depends now you and your understanding. If you are mature enough, you will understand things. Like myself, there are things I understand, and I will let them go if they have a probable cause that this was done for the purpose of success. That you let it go. Not every battle that you wage, you wage in life. There are battles you wage. When you wage a battle, you want to know, why am I waging my battle? Is it winnable? Why? Is it realistic? Is it measurable? So you think of those basic questions that governs you. So, in fact, the distance introduces delay every stage. Communication is mediated through email, messaging, application, time. So you see, you as a litigant who is abroad, these are the things you experience. Trusting lawyers from distance. So as I was discussing, you trust lawyers. You trust that they are going to appear in court. They are going to be honest. They are going to be sincere. And they are going to present material fact as established to protect your rights. What if they break that trust? What happened next? So you think about that. The registry failure and e-filing challenges. You may file something, it may go the wrong place. It may be a product. Maybe they didn't put the file for the charge for the specific case. So you also have to be very careful about those things. They are realistic. You have to have such an expectation. Case background and origin. You think about those things. Chronological case timeline. You understand your case very well. A typical procedure timeline may include initial filing of pleadings. So you keep those records. Service upon opposing party, preliminary hearing or measures, directions on submissions, filing or failure to file submission, delivery of ruling or judgment. So my book dives into many things. As somebody who is in diaspora, it is a book that will enable you to see the things that you may expect. You are buying a property, you understand the land registry, where the Ministry of Lands, the Registry of Land, like now we have the digital system. The title deeds are digitalized. You think about those things that are very critical in understanding how you process through the system. That is very challenging. It's not easy, but you're going to dive through the system. Lessons from diaspora investors. One of the clearest lessons emerging from litigating and involving diaspora investors is that ownership alone is not protection. Legal interest must be continuously documented and mentioned and enforced. Diaspora investors often assume that long-standing possession, family involvement, or informal understanding will be respected if disputes arises. When a dispute arises, dispute has nothing to do with it. Somebody can lie to the court, and you will think it will change a story today. It changes a narrative because he understands you are far. He lives maybe in your apartments, and he thinks, oh, he's far, he's in America. So he thinks he has rights than you, but also you also have rights. What about your rights? If somebody files and says you need to be condoned from your own investment, that person is out of his mind. Must be something wrong with that person. And he thinks that he has more rights now when you are litigating him, thinking that now you didn't follow whatever procedures. So you have to be vigilant and know your rights. Understand that family, there must be boundaries. You must set clear boundaries with family, whether it's your brother, whether it's your mother, there must be. If it's the power of attorney, you have to have limitation for that. You cannot sell this without my written consent. Even in the land registry, it says that the Ministry of Land or the county government of Nairobi, especially, is the lease owner. But you are now, you get the lease through the Nairobi county government for a certain number of years, and you have to follow that and renew it after 99 years. Others you may be given for 946 years. So that is how the system works. You understand. If you understand, you are informed, you're going to minimize your cost, you're going to minimize exploitation by these either lawyers, by anybody. So you are more informed about the system itself. Key reasons include importance of maintaining updated documents, ensuring that all agreements are formalized, verifying filing independently. So you can't rely verbal communication with your lawyer. Say, I filed. So you have trusted. But what if you get surprised there were no filing of your submission? That could take you even another time. So, my friends, be very well informed about this. Very minor things. They look simple, but no. Keep complete records of communication with counsel. So if you have text, you keep that. If you send him money to look for a file, you have records. So now this record, you are diving into facts. And these facts will stand over time, and they will test the legality, the trust, and all that kind. Protecting property and legal interests. Protection begin before disputes are preventive legal. It's like in medicine we talk about prevention is better than cure. it's better to prevent an outcome that is undesirable. So sometimes we may do things out of good faith. If a family member is sick, out of mercy and faith, out of good Samaritan law, you see, it's better for me to give him another second chance. But you risk your property, you risk your life. That is what happens. Now you are inviting dispute into you because they care less about you. They will even want you gone before because they see somebody is making an insinuation, even telling you bad words, and even you have taken care of them. So, brothers, be informed, be an informed citizen of the world and know your rights. Your rights don't change. Families are good. I love my family. Let me tell you, I love my brothers, I love my sisters, but boundaries must stand. They have to differentiate between a right and a privilege. A privilege does not become a right. If you stay in my property, you don't own it. You become an occupant. And there is a legal formality that if I cease to say that now from this time I have ended the agreement that you stay in my property, so that you have terminated that completely. Now it become reinforceable. You reinforce that. Whether you go say, oh, this, whatever, it's not going to happen because the trust is gone. Now you are setting boundaries. I can help you outside my property, it's okay. But within my property, you injure me, you cost me a lot, you cost me through legal filing and all that. There would never be a peaceful resolution. You don't mix your property, you don't mix your things with your family. You love them, you care about them, but they must be separate. When it comes property, separate, separate, separate. I give you a good example from the Old Testament, the book of Genesis. There's a dispute between Abram and Lot. They are quarreling, they are fighting, they are doing all kinds. Abram says, we cannot keep quarreling, fighting, and doing all this. You take to the north, I take this. Its separation is there. Even when God in Genesis says that a man shall take a wife, they shall be one, and they shall leave their parents and be united. So separation did not start now. Separation is a moral duty. Separation is a law of God. Separation creates resolution in problems. So there must be separation. We must separate things. Even in our kids' career, we talk of when we harvest, like corn, we are putting it in the granary. What we do, we have to sort out what is not needed to go so that it doesn't become a spoiler of the whole good things. So we must have that mindset of reality. You can't just blindly do things. Oh, I have a lawyer, I trust him, he's a good lawyer. It's okay. I can trust you, but I want to maintain our relationship. You must be accountable, you must be transparent, and you must be honest. Honest, honest, honest. There's no shortcut. So, brethren, this is a wake up call. You experience pain, but you take it as a moral lesson. You teach that lesson to the generations to come. We expand ourselves. We are creating an avenue. If it's a diaspora, confidence in diaspora, so they can invest without fear. They know their rights. They know how to process title deeds. They know how to navigate through the system. The code works and then you will succeed. Do not let these people try to eat because they think now you are in diaspora, you become their cash cow. They can make money because they know it's easy for you to give money. You can afford. But that's not the case. That's not about investment. That means it's exploitation of your disadvantages. So you want to be very informed and put in writing, because if somebody is going to behave, go silent, I would rather put everything in writing. We agree, this is what we are going to do. I have given you a document, I need this, this is what we are going to do. In that way, you are protecting your interests and you are protecting the relations between your lawyer and yourself. There will never be miscommunication. There will never be injury. Because then what if I'm not informed? What if I don't understand? I'll hate that person. I'll create an enmity which is not good. So once you are informed, you understand why somebody did something. And you are going to tell him, well, I understand what you did, but this is what you could have done. You are creating awareness. You are telling the person, I know what you did, but this is my approach. We can communicate, we can speak, but we need to make clarity. We need transparency onwards so that every side doesn't get injury. It's not just a case. It's about our understanding, our communication, our undertakings. Those things edify what you do in life and reality. For property and long-term investment, these include ensuring clear title and registration. So you obtain a title, there is a registration. Regularly conducting searches and confirmation. So you don't want somebody to otherwise come and claim your title and say, oh, about that land. Avoiding informal transfers or undocumented arrangements, separating personal trust from legal structure. So that if you trust somebody, it's going to change something, and later say it will, maybe 10 years later, it's going to deny a document that he authored. That's very dangerous. You think these are realities. So I'm not talking about stories. I don't talk stories. I talk of facts. And my book I wrote the book out of necessity, so that to inform, to educate those who don't understand our system, our people. They can change. They are very. Somebody can change and deny a document that he authored. He can now try to manipulate it. It is okay. They do that. They will go and put a stamp and say it was stamped in the United States. It was never. That's lying. That's manipulation of documents. That is also a criminal act. But they don't understand. The Kenyan system, we have to be very informed. It is not that we are attacking the system. We want informed citizens. Once citizens of a country are informed, they expound, they understand their legal system, the lawyers are informed that we are aware of what you can do. But also we want clarity. We want to make sure the court, we follow the court rules, timelines, and all that, so that there is an amicable understanding between parties. And not one party want to take the narrative, control the narrative. Well, once you discover something is wrong, he realizes it's no longer in control. It's no longer in the driver's seat. He's not controlling the narrative because you have discovered a weakness in him. Now, this is where injury comes. Now, there's total, total separation, total disconnection, because reality has kicked in. He doesn't control the narrative. You control the narrative. This is why you see some people will go silent. They are afraid. They don't want to speak about it. They realize if they were saying lies, you have discovered them. How are you going to explain a lie which can be recorded, which can be traced, which can be verified? See, my friends, be informed. Do not be blindly follow somebody, whether it's a lawyer, whether it's a file. Oh, the file is not there. Where did it go? The code is called the Code of Records. The Code of Records means that the court received a file in a certain year. Where did the file go? So you can, another way you can reconstruct the same file, because you have the facts which were filed and the stamps from the court. So the court has a right to do that. And you have such a legal rights to reinforce that. In that way, you are protecting also your interest in law. Stay tuned, my friends. Reflection on judicial reform. Reform effort must address transparency in the registry operations. In the registry, we want to make sure that our files are intact, our records are stored, our files are not manipulated. If somebody is not bribed and the file disappears, you want to be very clear on that. Accountability in electronic filing system. Clear standards for accepting rate submissions. If you read the code, in a code where submissions are just left, some people don't have timeline, some charges may not give you timeline. So there is a hindrance. you keep those timelines so that people can submit. If they say 15 days, 15 days, so that each person is given the same time. It's like, if you remember, there were cases were litigated that the defense is given a certain time, 30 minutes, 30 minutes, 15 minutes, 15 minutes, so that they can give their either written submissions or oral submissions. Those are practical facts. Yeah. Why do I say this? Me, I've gone even to the defendant's lawyer. He's so mad. He doesn't want to, he doesn't want now. When I tell him I want to take a picture, me giving you my submissions. He says, oh, I can't take it. You can't talk with me enough. You just leave it in his table and tell him, those are my submission. I've delivered. I'm the pontiff. And you act upon the submission. You are making, because for us who are far, we have a very limited time. And our time is measured based on our distance. So you are trying to do things in a very, you are driving in a fine line, trying to challenge the system, which is, to them, the system is okay with them. They can do whatever they want to do. You are in a distance now, they say, oh, it's in America. You see a lawyer standing in court saying, oh, it's in America. America's rules. We pay taxes. We follow the law. We have mortgages. We have family. We have rules. We have jobs. We do tax system things. It's not like a system where somebody relies on a few things and he can just waste time as much as he wants. So we must be. The courts must also recognize structural disadvantages by certain litigants, where equality before the law is constitutional principle. Equity is assessed to require awareness of practical barriers. Reform is not about diminishing judicial authority. It is about strengthening legitimacy. When litigants believe that procedure is applied fairly and considered, confidence in justice system is restored. The practical courtroom survival guide, litigant outcomes are shaped not only by law, but by execution. When litigants lose cases, they could have won because they treat court procedures as formality rather than the main battleground. A practical survivor guide helps to transform the litigant from a passive participant into active guardian of the record. So you are guarding your record. You know, court is a battleground. Anything can come there. Manipulated documents can be presented. So you have to be careful. Read your original documents. Make sure they are the original document. They are not manipulated. They are not altered. And who wrote that document? Any declaration, was it done before you or it is manipulated? So those are things that we must be very well informed. First, keep a written litigation log, record every instruction given to counsel, every date mentioned, every document filed, and every fee paid. Serve email messages and call notes. In court system where the record is decisive, your private log becomes a reference point for verifying what should be on file. You want to know that if I gave you my document, where did you take my document? Did you file them? It's not that you didn't have my files. I gave you enough evidence to go to court. What happened? If now you discover that he just asked you document and then have a file, then what did he do with your document? Holding your document hostage would be a criminal act to prosecute. But in Kenyan system, people don't see the law that way. Second, is it on proof of filing? So you don't want surprises at the end where somebody said, oh, that was missing submission. So where did the submission go? If you give me submission on my hand, I carried it through my hand goes everybody. Saw it. The whole world saw it. The defendant lawyer saw it. So where did they go? Did they have magic to fry? They don't. For if I demand the official acknowledgement, tracking number, and upload confirmation. If counsel says it is filed, respond with, please send the acknowledgement and a copy stamped accepted by the system. Because like in the Ministry of Land, if you do land payment, rent, you pay, it gives you a confirmation. So there is nowhere that somebody is going to say, if you paid well through your bank, like the Cooperative Bank of Kenya, you pay to the RAND or the e-citizen forum, they give you a receipt. So that's your confirmation. If you send M-Pesa to somebody's number, it may not have gone because people sometimes will give you the wrong number. They pocket the money. They go change the SIM card. But when you pay from the e-citizen through your bank, you can track the money where it came from. It went this, and this is the confirmation. If you go to the land ministry and your online portal for Adisasa account, you will see I paid this. So you have chronological. You see everything, and there's nothing that can change. So I invite most people in diaspora, if you are a Kenyan citizen, make sure you open your Adisas account. If you have land, if you have property, e-citizen. E-citizen account is for if you want to buy a vehicle, you want the logbook, you want a marriage certificate, you want to have the director of criminal investigation, your birth certificate, all those things. So be an informed citizen of the world. Make sure you have current passports. If you are a Kenyan citizen abroad, make sure you go like Washington, D.C., file for your passport. Make sure you have an ID here in the United States or any other place. Make sure you can obtain an ID, then file for your passport. Make sure all your documents are current. They are not only useful here, they will be useful in Kenya. You want to do land transfer, you need those documents. You need your national ID. You need to get to open a business. You need all those things. Don't take things with ignorance. You don't want to be fighting the system. The system is tough, but you are also to be an informed citizen of the world. Third, treat mission dates and directions as deadlines with consequence. A missed mission can mean misdirection. A misdirection can mean missubmission. Where possible, request that the council forward the daily case list or hearing notices and confirm attendance in writing. So somebody needs to communicate, I attended court on this date, this is what was discussed. So you are well informed about those facts. Fourth, understand the difference between narrative and proof. Courts decide on admissible material, breedings, affidavits, annexures, exhibits, and submissions properly placed on the record. You want to make sure all these things are on record. A story that is not supported by record is often ignored, even if true. Finally, anticipate delay and plan for it. Build extra time into every step, service filing and confirmation. If a deadline is approaching and the record is incomplete, act early. In practice, the party who escalates hurrier to correct the record often avoid inevitable procedure laws. Building evidence bundle that survives court scrutiny. So my book is a good book. It's just it's like giving you information. I know some people would think that we are abroad, we don't know the court system. Technology has come, and through technology, we are going to be more informed, more organized, and change. We have to impact change through the way we do things in a just way. We have to be informed. So my book has a lot to talk about. If you look at my book, it will say a Kenyan legal terms. Here I speak about affidavit, appeals, directions, e-filing, hearing, judicial discretion, mission, breedings, registry, ruling, service. So you understand affidavit of what's an affidavit of service? What's case management? The court process for organizing timeline, direction, and readiness for hearing. Case list, the daily list showing which cases will be heard and in what order. A degree, what's a degree? When a judge says a degree, he's saying the formal order extracted after judgment used for enforcement. Ex parte, presiding conducted in the absence of one party usually because they did not attend. Injunction, a court order stopping a party from doing a particular act. Interlocutory application requests made during a case before judgment seeking interim orders. It's like when you are seeking interim orders, now the probability of parents, they say this one is benefiting, this one doesn't benefit. Now you want to bring those mandatory introductory orders so that each party doesn't lose. President, the period during which a case remains active before final determination. Review, the same court to reconsider decision under specific legal grounds. Annex a document attached to affidavit as supporting evidence. Affidavit of service, a sworn statement confirming that the court documents were delivered to a party. So normally, affidavit of service, if you want, the other party may say, I was not served. So you want to make sure that that he received, he signed, and you keep a copy. You have two copies. One he signs, and he signs both. You take that to court. Then the court is made aware that the affidavit of service was served formally to the defendant. So the defendant would not come and go, oh, I was not served. He may be firing. He may run away, trying to survive. So is it like in America, if somebody, like if there are some cases, which happens, and what the law says, if somebody like a squatter, you are trying to evict a squatter, and you submitted, you put it in our door, you went inside, she came, she saw that. She was sent another one through the email. She could have corrected that. She was sent a message she didn't receive. Now the court will give her even 15 minutes before they can make a final ruling. So they have made everything sure that this person received the proper notification. The proper notification is a notification to certify the court that the person received proper service through the sheriff or to any person. Now, when the ruling is passed, the person was given another grace time, which is like 15 minutes, before the judge comes down to make the ruling. So you can go. I've seen cases where somebody, a landlord, can litigate the case by himself. You don't fear. Because if you have the correct documentation and the correct facts, you can prove, even in the Kenyan system. You should not be afraid. Because a lawyer goes silent doesn't mean anything. It means he's afraid of his own himself. He's not trustworthy. So you leave him alone. You're not going to fight with somebody who's not ready to fight the facts. Or he was bribed to go away. So people do things, whatever pleases them. You don't care about that. You want to protect your interests, your rights, your property rights. Not somebody who is not ready to do so. Before filing, confirm ownership records and obtain an official search. Gather key document and create best timeline. Choose counsel and agree on communication, expectation, and writing. After filing, obtain a structured briefing, e-filing acknowledgement, confirm services and keep proof of service service stored. Track mission dates and direction on calendar. Before submission, confirm direction and deadlines. Draft submission area and approve a final version. So if you are e-filing, you want to make sure I submitted, I got a copy. What did the judge tell me? The judge told me on July 1st, 2025, I have to give a hard copy to the registry. You go to the registry. That's why you as a litigant, you make sure you give your lawyer even money, and you give another copy to somebody else you trust. Now you have a second person. He may not have submitted. You have given another second person to go take the same document. So if this one didn't go, you surprise him at the end. It is there. It is in court. So you are covering him in another way that he less understands. Think of a case where a judge is telling the lawyer may tell the judge, oh, the judge may be looking at these cases, and they didn't see he filing. Now he tells you go put a hard copy in court. You don't do that. Whose fault is that? It's not the client. It's not the church. The church has washed his hand as a Portia Spirit School of Management Law states. So the lawyer is put under strict proof to provide facts, which he cannot. Then total disconnection happens. You don't want that. Jules can't agree that. So before ruling and shall confirm the file is complete, submission and affidavit and annex, request a registry check. If you are near, you can either send somebody to the registry to confirm all these things are there. All your documents, all your evidence and all that. Give a backup copy of a full bundle and timeline. So this book is a good book. I've dived in many things. I've put many things. So this book will help you as a diaspora, whether you are anywhere in the world, to be a well-informed citizen. I also dive family boundaries as a key to success, justice, and peace. So just because it's your brother, you love your brother. I love my brother. But there must be boundaries. Many cases that end up in Kenyan court do not begin as a legal dispute. They begin as a family arrangement, informal, verbal, trust-based, and undocumented. They begin with good intentions, shared history, and emotional bonds. What transforms them into Peter litigation is not law, it is the absence of boundaries. So now boundaries becomes the key. The chapter argues that the clear family boundaries are not a sign of mistrust. They are a prerequisite for success, harmony, and justice, especially in matters involving land, money, and diaspora investments. The culture trap of informality in many Kenyan families, formality is mistaken for austerity. Written agreements are viewed as an insult. Documentation is written as a lack of faith. Boundaries are interpreted as rejection. This is somebody will say, you are greedy. You're not greedy. You're protecting your rights. You're a human being. You're living in two worlds. So somebody must understand why boundaries are needed. Even Abraham understood. That's in Genesis, many years, thousands of years ago. Abraham understood that functional duty. It is not a crime to have boundaries. You educate somebody so that he goes out there to become responsible of his own action, to protect his own wife. If he fails, let him fail on his own. You can help, but you don't have to carry somebody for the rest of your life. Clear boundaries, get somebody active in doing his own things. So do not let we are family. When family replaces law, a recurring pattern in Kenya litigation is the situation of family status for legal. So you think about this. We are family boundaries are not barriers to love. So when you put boundaries, you're not putting a barrier to life. You're trying to make reality. You also want to exist. You want harmony with your wife. You want harmony with your kids, your parents, your sisters, your siblings, so that your community at large, you want also to excel. You want to preach. Even counsel, when honest now, becomes a duty. Me, I don't take it personal. I take it as a challenge. If somebody went silent, I'm going to go and show him what he could have done better, because I have to help him realize we are not enemies. We have to inform the citizen. We have to inform the people, the common people, to understand the reality about litigation, distance, what damages it can do. When one wrong is taken as everything is complete damage, you want also to understand the whole picture to see reality. Brethren, stay tuned. These are the good books. So I dive in many things to see how our legal system has worked, what we can do, and how. Our cases, a case can be, you end up that, oh, the case was dismissed. How? because no submissions were submitted. So somebody either he has talked to other lawyers, now they say, oh, don't kill us, don't kill us. It's a Kenyan system, it's our culture. So somebody now it takes the soft side. Maybe they bribe him. Oh, we are friends here. We'll treat you nice. But he fails to understand you are also human. What if you discover? Now you become your driver. You are on the driver's side. He's gone. He has destroyed that trust. A person like me, I give you my trust 100%. You do the same. What guides me all over time is the golden rule. It is said, do to others what you would want them to do to you. In this rest the law. In such there is no law. For this rest the law and the prophets. Even the disciples of Jesus, when they asked Jesus, Master, which is the greatest command of all this? Jesus answered, love God your God with all your soul, heart, and mind. Second, love your neighbor as you love yourself. In these two rests the law and the prophets. The prophets spoke of the law of Moses, the Mosaic law, the canon law that is given, the natural law. And then there is man-made law, the laws that have guidelines to govern people. If you did what you were supposed to do, that's what Paul argues in the New Testament. You don't need the law. The law is a mirror for wrongdoers. So stay tuned as I dive to experience the diaspora legend, the diaspora life, how our systems are busy, how we act. We don't act with violence. We don't act to accuse. We don't act with greediness because we sacrifice. In my books, I dive about life of a diaspora person. Hello. Hey. All right.